Welcome to VA Made Easy. I'm VA-accredited attorney and U.S. Army combat veteran Ed Farmer. In this video, we're going to break down how my firm got a veteran 100% of a bipolar disorder despite there being no treatment in service, no diagnosis in service. In fact, there was hardly any evidence at all. This case is going to show how, with some lay statements and the correct legal argument, you could take that unwinnable case and make it 100%. If you've been denied your claim, visit me at vetlawoffice.com. We provide zealous advocacy. We'll help you get those lay statements. We'll get you those medical nexus opinions. There's no fee unless I win. Visit us at vetlawoffice.com or call us at 1-800-700-4174. All right, let me give you a little background about this client. He has bipolar disorder. He was denied his claim. He was already turned down by two other VA disability lawyers who said his case was unwinnable. And I mean, to be honest, it was a tough case. But if you have the right advocate, somebody with the right experience, you could still win your claim. All right, so here's what we're facing here. No in-service event. There was no treatment for bipolar. There was no symptoms for bipolar. He wasn't diagnosed till like 12 years after he got out of active duty. The VA said there wasn't even enough evidence to give him a compensation and pension exam. By the time this guy contacted me, he was really struggling. He was nearly homeless. He was depressed. He couldn't keep a job. And this VA claim was the only thing he was holding on to. So I decided to take a chance on him because I thought I could win it. So we really had to build this case from nothing. When I took it on, it was already at the Board of Veterans Appeals. The last lawyer left him hanging there. I got the judge to grant us additional 90 days to get some new evidence. Well, this is where the real work began. I mean, what new evidence am I going to get? What did I get myself into? So there's three things you have to prove in order to establish service connection with the VA. One, you need a current disability or diagnosis. Well, that's about all we had. He had the diagnosis of bipolar disorder, even though he wasn't diagnosed till many years after active duty. If he was diagnosed within a year of being discharged, then there's a special presumptive rule I could have used, but that wasn't the case. Two, you need an in-service event, disease, or injury. Nothing in service records, was never treated. He tried to say that something traumatic happened to him in service, but we had no way of proving that. And three, you need a medical link between the current disability and the in-service event, disease, or injury. We didn't have that either. As I said before, the VA hadn't even given him a CMP exam. So I had to figure out, what is causing this guy's bipolar disorder? Why does he think it's related to his military service, even though he didn't get diagnosed till 12 years later? And that's where a good advocate, a good investigator will come in and try to establish that. So after talking to him for a while, I learned that he experienced a change in behavior shortly after he went to basic training. Racing thoughts, being too talkative, staying up for days at a time, making bad financial choices, all followed by emotional lows and depression for days at a time. Those symptoms I'm describing can be indicative of bipolar disorder. However, those symptoms were not recorded in his service treatment records. He had no misconduct either. He was able to keep himself together despite going through this change shortly after going to basic training. But I knew that was the key. And in the VA world, you don't necessarily need a military record or service treatment record to corroborate what you say. Lay statements, or some people call them buddy statements, can prove your claim. Veterans are usually considered competent to report their own symptoms, and other people are competent to report what they observe. So we got a statement from the veteran about all these symptoms he experienced in service, but I knew it wouldn't be enough. The VA would have wanted some more corroboration. So what I learned is he used to call his mother late at night when he was going through these symptoms and talk to her about it. So I called his mother. She remembered the late night phone calls. She remembered the erratic behavior. She remembered the poor financial decisions. She remembered him saying he's staying up for long periods of time. And then she would notice he was depressed for long periods of time. So we got a statement from her detailing all these bipolar type symptoms. And now we had our in-service event. We had a statement from him and a statement from his mother stating that these bipolar type symptoms, now we were not medical doctors, so we didn't know they were bipolar at the time, but we knew that these symptoms began shortly after he went to basic training, and he did not have them before basic training. So now we have the current diagnosis. He has bipolar diagnosis. He has an in-service event as established by the lay statements. The last thing we needed was a medical nexus opinion linking that current diagnosis to these events in service that his mom and himself described. And now remember, the VA said he didn't even meet the criteria for a compensation and pension exam. Now, some of you may think that it's automatic when you file a claim that the VA is going to send you to exam. And actually, that is not true. It is not automatic. You have to meet certain criteria in order for the VA to give you a compensation and pension exam. And there are 4 criteria you must meet. And these are called the McLendon criteria. And that's the name of the case that established these 4 elements. Now, these elements sound very similar to the elements needed to establish service connection, but they are not. They're different. There's actually 4 of them, and the burden is lower for some of them than it is for establishing service connection. So let's go over the McLendon elements, the elements necessary for the VA to give you a compensation pension exam. 1, you need evidence of current disability. Boom. We had that. He had the bipolar disorder diagnosis. 2, you need some sort of evidence that something happened while on active duty. We had that with his statement from his mom and himself. 3, now this is one that's a little bit different from the service connection element. You need a possible connection between your current condition and the in-service event. So this is a low threshold. This is not the 50-50. This is below the 50-50. So it's just a possible connection. And we had that because the symptoms described by him and his mother were similar to symptoms of someone experiencing bipolar disorder. And number 4 of the McLendon elements of what you need to establish to get a CMP exam, there needs to be not enough evidence in the file for the VA to be able to make a decision without an examination. So in this case, there never was an exam. There is no nexus opinion. There is no opinion looking at the lay statements and making a decision if those symptoms are bipolar or not. So I argue this to the board judge that he's entitled to exam based on these lay statements, and the judge agreed. She sent it back to the regional office. This is called a remand. It's not a denial. It's not a grant. Board judge needs additional evidence or thinks that something wasn't done correctly down at the regional office, they're going to send it down to the regional office in a remand so the regional office could fix that error. So some of you may be thinking, great, you just got kicked back to the regional office. But in this case, that's what we wanted. We wanted them to send it back to the regional office because we needed that medical opinion. And the medical opinion is where the breakthrough came. So what happened is the examiner looked at all the symptoms as recorded by himself and his mother and said, yeah, those were as likely as not symptoms of bipolar disorder. Boom. Service connection for bipolar granted at 70%. But wait, there's even more. There is more. So I've talked about in the past the VA's duty to infer a claim for unemployability despite you ever asking for it or filing at 8940. If you meet the schedule requirements of unemployability, and that's having a combined rating at 70% with at least one rating at 40 or one rating at 60%, you meet the schedule requirements, and there's evidence of unemployability in the file, so evidence that you can't work due to your service-connected conditions, the VA must infer a claim for unemployability despite you ever asking for it. And in this case, he met the 70% schedule requirements, and he had frequently talked in his CMP exam about how he can't work due to his symptoms. Unemployability granted going all the way back to 2020 when he started the 70%. He went from homeless to 100%. This guy's life was changed forever. So you know what this case proves? This case proves that no matter how many people tell you your case is unwinnable, maybe you're just not talking to the right person. It also shows how powerful lay statements are. You should be getting lay statements for almost every single case you have. And it also proves that with the right knowledge, you can win your case. If you're struggling with your claim or you've been denied your claim, visit me at vetlawoffice.com. There's no fee unless I win. Keep liking, keep sharing, keep subscribing. And as always, you have the power to change your VA.